Welcome back. Lost in the onslaught of pandemic headlines, the Supreme Court made a landmark ruling recently that makes it illegal for employers to discriminate on the basis of sexual orientation or gender identity. But a lot of questions remain here, which is why we invited Ed Herman to join us this morning. Ed is a partner with the law firm Brown and Crouppen. Ed, it's good to connect with you. So talk about a below-the-fold story. This one really kind of got lost in modern day headlines. What exactly did the court decide, and how does this change things?
Well, this one's really big. For a long time, people have heard of Title VII and the protections that people have that prevent people from being fired for certain reasons, what we call protected classes. So, for example, before this decision, we already had it where you couldn't fire a person based on their race, you couldn't fire a person based on their gender, you couldn't fire a person based on their religious beliefs, because of a disability or because of their age. So these were protected classes where, obviously you could fire these people, but you had to have cause. And your reason for firing them could not be simply for one of those things listed. But before this decision, you were still allowed, unless your state had a particular law against it, but you were allowed to fire a person simply because you found out that they were gay, or they were having a sex change operation, or they were transgender. And what the court looked at here was actually three different cases that were all combined into one. And each of these cases had a different example of a person who had been fired because of their sexual orientation. They were doing a great job otherwise, and that was the only reason they got fired. What makes the decision interesting, Matt, is that, right now we have a conservative court. Typically we have a 5-4 split in favor of conservatives. And a lot of people would have expected that, they would not have expanded this Title VII to include sexual orientation. But as it turns out, the court decided by a 6-3 margin that sexual orientation should be included in Title VII and should be added to the list of things you can't fire a person over.
So, Ed, there have been a number of incidents across the country that have made it into the national headlines where organizations or small businesses had religious objections to servicing LGBTQ individuals, basically refused them service. Does this decision have any bearing on those kinds of cases?
It doesn't yet. The court is going to hear another case, probably for next year's decisions, that will shed some light on it. This one is very specific to employers and their employees and whether they can fire them. There are some questions that are also coming up. A lot of times it's religious beliefs that are cited as reasons, that they don't want to serve particular parts of the community. But they are going to be looking too, if those organizations are getting certain tax exemptions, whether or not they're going to be allowed to discriminate on those kind of bases.
At the beginning of this conversation, we called it a landmark decision, and I think that's a fair adjective. Ed, thank you so much. We appreciate it. Stay safe, okay?
Of course, you too.
All right. If you'd like to get in touch with Brown and Crouppen, you can call them anytime at 314-222-2222 or check out their website. That's getbc.com.